Well, good morning, everybody, and welcome to the Employment Law Update 2021-2022 Part 2. My name is Beth West. I'm chair of the Labor Employment Group here at Weintraub Tobin, and I'm going to present this webinar today with four of my esteemed colleagues here in the L&E group, James Kachmar, Brendan Begley, Ryan Abernethy, and Meagan Bainbridge. And hopefully, a number of you were able to attend part one. We broke up our webinars a year or so ago in this fashion because these year-end webinars are really survey webinars where we're trying to give you an overview of developments in the various areas of employment law. And oftentimes we found that we were just rushing because there was always a lot of updates in the wage and hour sector. So part one was wage and hour. I hope you were able to attend a week ago. Part two today is everything else, a catch-all. And so we have a lot to cover in our allotted time. And while we could go into great depth, probably in some of the subject areas, we're unfortunately not going to be able to do that. So let me just do a little housekeeping. An e-blast went out shortly before the webinar with a copy of the presentation. So hopefully you have that. It also has information about how to request HRCI or MCLE credits for the lawyers who are on the webinar. If you happen to register late, don't worry. Another e-blast is going to go out after the webinar with a copy of the presentation. So you'll have that. And it'll also have some other information, including links to our employment law blog and our COVID-19 resource hub on our website. Because we're going to cover a lot of material, we're not going to use the chat or the raised hand function today, but if you have a burning question, go ahead and put it in the Q&A. Hopefully, your question may be answered during the presentation, but if not, we'll do our best, time permitting, to answer some questions at the end of the webinar. And of course, those will be hypothetical questions that you pose and general oversight responses, because we won't be giving legal advice directly on any particular legal issue on the webinar. Of course, if you do have a pressing legal issue, well, we are the employment lawyers here at Weintraub Tobin, and we're happy to assist you in that regard. So go ahead and sit back, and we're going to get going here. I'm going to see if my slides work. These are your presenters today, as I introduced. There are their mug shots. Mine's rather old. You can see I don't look like that anymore. Age, what a drag it is getting old, right? Remember that song? Okay, so let's talk about the subjects that we're going to cover here, if I can get my machine to work. We're going to start off with health and safety, and of course, the pressing, or I should say oppressing, topic of COVID-19 and various federal and state mandates. Then we'll talk about leaves, reasonable accommodations, harassment, discrimination, and retaliation, some developments from the NLRB. And then in California, there's quite a few new developments in connection with certain agreements in the employment arena, arbitration agreements, restrictions in connection with severance and settlement agreements, and some other agreements. James is going to talk to you about that, as well as covenants not to compete and trade secrets. Then Ryan will take off and finish up talking about employee privacy rights, social media, and the ministerial exception. So I'm going to get us started, and then I will get out of the way and let everybody else take over. But we are going to start on this topic. And the reason why is because I can understand, because I've experienced this with my clients, that this is the topic that is just draining your brain every day right now. In addition to all the other employment law issues and HR issues you're trying to deal with that always existed, you are now also grappling with COVID-19, keeping your employees safe and healthy, and trying to comply with whatever the ever-moving mandate is. So again, we could spend hours and hours on this, but what I'm going to do is just try to kind of tell you where we are currently and what's happening. So just a reminder, this is not new, that California employers have to comply with health and safety laws in the workplace. Okay, that's always been the case. And really the COVID-19 mandates that we're seeing is part of that mandate to make sure that our employees are reporting to work in a healthy and safe work environment. And part of that is the implementation and enforcement of an injury and illness prevention program, an IIPP. And the reason why I started with this slide and want to remind you of this is that COVID-19 and the potential for outbreaks in the workplace is giving Cal OSHA the opportunity to come in to workplace settings and do certain inspections or reviews for compliance with COVID-19 safety standards. And one of the first things that a OSHA inspector will want to see is your IIPP. So you really need to make sure, not that I want to burden you with one more thing that you need to put on your plate for all of you HR people out there, but you really need to make sure that your IIPP is actually current, up to date, and is actually being enforced. It has to be a living document. If you've got it tucked away in a drawer somewhere and it was prepared 15 years ago and you're not doing inspections to see if there are new potential hazards in the workplace and you're not training employees, you could find yourself being cited by Cal OSHA for having an ineffective IIPP. And then you've got to make sure that your supervisors comply with the IIPP as well and enforce health and safety rules with all the employees that they supervise. And again, it's becoming quite an important document as we find ourselves in this COVID-19 pandemic world. Okay, so with that, let's talk about COVID-19 and where we're at, what we know, what we don't know. We're going to start with California. We do know that the California OSHA ETS, Emergency Temporary Standards regarding COVID-19, are in place and effective, okay? And they require various things. One is that an employer implement and enforce a written COVID-19 prevention program. It could either be a separate program or it could be part of an employer's IIPP. And here I just summarize some of the things that have to be included in that program. You've got to identify who your vaccinated and unvaccinated employees are and then comply with certain safety protocols, for example, masking. What we do know is Cal OSHA's ETS does not currently require that employers have a policy that require vaccination or testing, like the federal ETS for large employers does, which I'll talk about in a minute. But you do need to know the status, the vaccine status of your employees, because there are masking requirements under the ETS. Unvaccinated employees need to be masked in certain circumstances. Now, of course, in certain counties and cities that you may live in, everybody may be required to be masked regardless of their vaccine status, but under the ETS, it only refers to unvaccinated employees. And then there needs to be communication with the employees as to what the requirements are, training under that. And then the employer has to be able to identify and evaluate workplace hazards that could give rise to the spread of COVID, make sure there are effective face coverings being worn, and then of course, how to respond to COVID-19 cases and or outbreaks. And as I just mentioned, it appears that when an employer reports potentially an outbreak of COVID in the workplace and Cal OSHA comes out to see, did they have their COVID-19 prevention program in place? Did they do everything accordingly? That Cal OSHA inspector has the ability while they're there to do what is referred to as a walkthrough or a walk around. And if they identify other potential hazards in your workplace or that you don't have a compliant IIPP, they will go ahead and potentially take action on that. They can issue citations, even though they were just there to determine whether you properly responded to your COVID-19 outbreak obligations. So that is why I'm reminding everybody that make sure your IIPP is up to date and that you're properly enforcing it and complying with health and safety laws. So the ETS, as you can see from the first bullet point here, was amended just a little bit a couple weeks ago on December 16th, and that became or will become effective on Friday. And really the main amendment here was to bring it in line with the California Department of Public Health's recent publication, where they're modifying the quarantine period and the ability to return to work. And so that is really what the Second Amendment dealt with on the ETS. But otherwise, the ETS is essentially what it was after its original publication and First Amendment. And the Cal-OSHA website has a number of resources for compliance with the ETS, and also has some FAQs and some fact sheets to assist you in compliance. Now, currently, the California ETS is set to expire in mid-April of this year, so not too far away, a couple months away. But there has been some indication by the agency that it's going to adopt new standards, potentially to extend the ETS, and we're thinking we'll see those sometime by mid-March if they do so. And then the governor issued Executive Order N2321 recently, and made clear in that order that it could permit the ETS to continue to be enforced through December 31st of this year. So really things are very flexible in connection with the Cal-OSHA ETS based on where the state is with respect to its COVID-19 cases. You know, we've got this Omicron variant that's spreading pretty quickly, even though people are saying that the consequences are not as bad. People aren't getting as sick, but if we see it spreading quickly and a lot of people getting sick in the workplace, they may go ahead and continue to extend the ETS. So that is California. It's in place. It applies to all employers. It's not a large employer mandate like the federal OSHA standard that I'm going to talk about next. So what do we know about the federal OSHA ETS? This is referred to as the large employer mandate, and it applies to employers with 100 or more employees, with a couple of exceptions. And what it says is that the covered employers must implement and enforce either a mandatory vaccine policy or a policy that says you either have to be vaccinated or undergo regular COVID-19 testing on a weekly basis, and then follow certain protocols, masking and so forth in the workplace. Now, if you've been following the news, this emergency temporary standard, the federal standard, was challenged very quickly, and a court, the Fifth Circuit, stayed the enforcement of it back in November 12th. Then we had a number of challenges all consolidated into the Sixth Circuit. The stay stayed in place, and then on December 17th, the Sixth Circuit lifted that stay. And because of all of that, OSHA then said, okay, we're really glad they lifted the stay, and it now is in place. It is a federal legal mandate, but we're not going, we're going to push out compliance dates, and we won't issue any citations for non-compliance before January 10th. And if we find that it's just a testing requirement that might not have been complied with, we won't issue any citations until February 9th, 2022. So that is where we're at. Well, those who had challenged and originally obtained the stay didn't like that. And so there were petitions to the US Supreme Court to determine whether the stay, in fact, should be put back in place, whether federal OSHA had the authority and the jurisdiction to adopt and enforce the ETS. The US Supreme Court had hearings on this question last Friday on January 7th, and then some additional argument on Monday, January 10th. We do not have any decision from the US Supreme Court, but I can just tell you a little bit that essentially a lot of the questioning was really split, as you can imagine, between the justices. A number of the justices who may be referred as the more liberal justices were very focused not on the legal challenges to the ETS, but more on the public health crisis and factual aspects of the issue. They were emphasizing, with the Omicron variant, the hundreds of thousands of people in the country who are becoming ill, infected and ill by COVID. But the legal argument and the questioning by others, including Justice Kavanaugh and Chief Justice Roberts, are focusing on whether OSHA really had the jurisdiction and the authority to adopt the ETS by Biden's order, instead of being expressly authorized through an act of Congress to do so, and that in adopting the ETS, OSHA didn't follow the normal notice and comment period that is usually required under the Administrative Procedure Act. So there are factual issues that are very concerning here because we're living through a pandemic. Matter of fact, going into year 3 of living through a pandemic, but also some very serious and important legal issues. And so we expect to hear something from the Supreme Court, hopefully this week. The question I'm getting, even from some clients as recently as yesterday, is, well, does everybody just still wait and see if they're a covered employer under the federal ETS? Is it enforceable or not at this point because the Supreme Court is undergoing this review? There is not a stay on the ETS. They are in fact in place. But here's an important thing to know about California, and that is that California is one of a number, maybe 2 handfuls, I don't remember how many, 25, 28 states, that is a state-sponsored state, which means they are authorized to adopt and enforce their own health and safety rules for the workplace in the state of California, rather than the federal OSHA adopting those rules for compliance in California. The way it works, however, is that California has to make sure that its rules are as, quote, at least as effective as the federal OSHA rules. And so if, in fact, this federal OSHA ETS is not stayed again and remains in place, the way that works, and if you look at Cal OSHA's FAQs on COVID-19, if you go to the vaccine section, FAQ number 9 makes very clear that if federal OSHA adopts the standard obligating large employers to either have a mandatory vaccine policy or a vaccine or testing policy, then California has up to 30 days to either adopt the same standard as the federal OSHA ETS or a standard that is at least as effective as the federal ETS. So we will be seeing some activity in this regard if, in fact, the Supreme Court does not again agree that the ETS should be stayed. If it continues to move forward on a federal level, then Cal OSHA is going to have to do something to ensure that it is in line or at least as effective as the federal ETS. One other issue that has come up in connection with this federal OSHA ETS is that if you read the language of it, which if you guys saw it when it first came out, it was like 480 pages or something, but really only the last 17 or 18 pages is the actual mandate. The rest of that is all background and kind of supporting information as to why OSHA thinks it can enforce it. But one of the provisions says that if an employer adopts the policy of either vaccination or testing, that an employer is not obligated to pay under the federal ETS for the cost of the testing. The burden is on the employee to pay for the testing. Essentially, and this is me interpreting it, but I think the rationale is that federal OSHA said if we put the burden of testing on the employee and they have to get tested every week and they can't find free testing, then maybe they don't want to pay for the cost of testing and they'll go ahead and get vaccinated if they can. But it also has some saving language that says, while the employer is not obligated to pay for the testing under the OSHA ETS, the employer could be obligated under other laws, including under state law, to provide to pay for the cost of testing. And so that raises the question in California, are there other laws in which employers have to pay for an expense that's required by an employer for an employee, and the employee incurs it based on working? And so the California Labor Commissioner has some FAQs out that says that employers are obligated to pay for the cost of vaccination and or testing. And even though an employer may be providing an employee with a choice, get vaccinated or tested, the argument is that if they choose testing, the employer still has to pay because the employer is giving them the option. And the testing is related to their employment. It's a condition of employment. So as we currently understand it in California, even though the federal ATS says employees are responsible for testing, California law would say employers are responsible for testing. And again, if and when we see Cal OSHA update its ETS to be in line with federal OSHA, maybe there will also be further guidance in that regard. Okay, so we could go on and on and on and talk about the COVID-19 mandate, but that's not the sole purpose of today's webinar. So we're going to move on. That is where we are currently, what we know and don't know. And really, it is an area where everybody just needs to be watching the news out of the Supreme Court and checking Cal OSHA and federal OSHA websites pretty regularly to see what developments are happening. Okay, with that, we're going to leave that, and I'm also going to talk to you about some developments in the leave laws. There wasn't a whole lot of new developments here, one particular piece of legislation out of California, and then I chose just a couple of cases that I thought had some interesting pieces of information, some fact patterns that I think some of you probably deal with, and thought you may find it interesting how the courts were addressing those fact patterns. So the first slide addresses Assembly Bill 1033 out of the California legislature. And what this did, excuse me, was amended the California Family Rights Act to provide for an expansion of who a parent is under the California Family Rights Act, the CFRA. So it adds parents-in-law to the definition of parent. And as you all know, the CFRA was amended last year, effective this January of 2021, to cover a lot more employers in California. It used to be a large employer law, only applied to employers with 50 or more employees, but effective January 2021, it covered small employers, right? Employers with only 5 or more employees. Well, now it's even going to provide another potential leave entitlement for somebody who does qualify for CFRA, and that is that if their parent-in-law has a serious health condition, that will be protected leave under CFRA, assuming all other eligibility requirements are met. The bill also then modifies a little bit the small employer mediation program that the previous bill adopted back in January 2021. So for small employers, the ones who are newly covered by the CFRA, but even smaller, those with 5 to 19 employees, they have a right to pursue mediation before an employee can bring a civil lawsuit for a violation of the CFRA. And there are certain logistics and kind of procedural measures that are included now in the statute. The DFEH has to notify the employer that the mediation program exists. Either the employer or the employee can request that mediation. And if it turns out that the employer wanted to mediate, but the employee files a lawsuit as soon as he or she gets their right to sue letter, because remember, you can get a right to sue letter immediately upon filing your DFEH charge. You can ask the case to be or the file to be closed and a right to sue letter be issued. If an employee does that and files a lawsuit immediately, an employer can seek to stay the lawsuit if they did not receive the required notification that they could seek mediation. Also, if, however, one of the parties does seek to participate in that mediation, it also stays the statute of limitations. The statute of limitations on a later civil lawsuit is stayed from the date of the request of the mediation by one of the parties until the mediation is concluded. So that really was our only piece of legislation that affected, you know, a main leave of absence statute here in California, and that was AB 1033. And let's see if I can get my slides to work. Okay, so now let's talk a little bit about some cases that I thought may be of interest. So this first case, Lars versus LA County Metro Transportation, really dealt with whether an employer's absentee rules violated the CFRA. And what happened here was the employer had this policy that disciplined employees if they had a certain number of absences. You got demerits. But each 60 consecutive day period of work that the employee worked without any absences, then they could start to erase previous demerits from their total absences. And so in this particular case, Lars, the plaintiff, went out on CFRA leave. And prior to doing so, he had 2 absence demerits on his record. But the employer, while he was out on CFRA for over 60 days, did not count his CFRA leave days, even though he was still employed, to clear the prior demerits. And so he ultimately comes back to work, gets more demerits, gets suspended, then ultimately gets terminated. And he sues when he's terminated, saying that their failure to erase his demerits while he was out on CFRA and more than 60 days had gone by without an unexcused absence was a violation of the CFRA. And he was pointing to, there's a provision in the regs, it's section 11094B of Title II, that says that CFRA leave can't be counted against an employee under an employee's attendance policy. And he was interpreting that provision to say that by not counting the 60-day time period that he was on CFRA leave to clear previous demerits was counting it against him and therefore violated the CFRA. It was an interference with the CFRA. But the court distinguished the facts in this case and said, no, this no-fault absentee policy wasn't being used against him because he was on CFRA leave. He wasn't being given absence demerits while he was on CFRA, but essentially this was purely a clearance policy, essentially an absence clearance policy. And so the holding of the court was that where an employer's no-fault absentee policy provides that an employee may clear absence demerits during a certain period of time, including 60 days of working, the employer does not violate the CFRA by extending the clearance period during an employee's unpaid CFRA leave where the employee is not working, right? So they're not meeting the requirements for the clearance, as long as that policy is applied consistently for various forms of protected leave. So that was an interesting case. And the next case in this area, whoops, too fast, is this Snyder versus EI DuPont. Now this one, I just want to caution you on. It was very interesting, and I think it's something that employers and HR people grapple with pretty regularly, and that is suspicion that employees who go out on a protected medical leave under FMLA or even an accommodation leave under ADA and FEHA may abuse it, and maybe not even initially, but maybe over a period of time after they've healed and can return to work, they are still out, absent, and there's some suspicion that they're perfectly able to return to work and work, but they don't. And so in this case, the plaintiff did have surgery on her foot and provided documentation by her healthcare provider that she was going to need 3 months of FMLA leave to recover. But partway into her her FMLA leave, the employer is told by certain employees that they've seen the plaintiff, Snyder, walking around at a pool party. And other people were talking about how, you know, she's out and about. She doesn't seem disabled or recovering. And so they think she's taking advantage of the employer's leave policy. So the employer hires a private investigator to conduct surveillance of the plaintiff. And they do it while she's still on leave. And even when she comes back to work, because when she comes back to work, she claims that she's still in pain and she can't work full time because she can't be on her foot. And so they surveil her and they find all kinds of things, that she's climbing in and out of her Hummer, she's walking around her backyard and downstairs, she's off and on some lawn tractor, mowing her lawn, picking up kids off the ground. I think there was even, I don't know if this was when she was on leave or even after she returned, but she was at a beach, you know, in the ocean, and just showed no signs of any kind of restrictions. So ultimately, they find that she's kind of gaming the system, maybe on a fraudulent leave and or accommodation, and also violating their code of conduct by not being forthcoming, and they terminate her. So she sues, as you can imagine, and DuPont seeks a summary judgment motion to have the case kicked out of court, said it had a legitimate non-retaliatory reason for terminating her. She claimed her termination was in retaliation for taking FMLA leave. And they produced evidence, right? They had all this surveillance evidence from the private investigator. So they produced all this evidence that showed that, you know, she exploited their disability policy and she disregarded maybe her treating physician's restrictions, at least the ones that she submitted saying that she had, and was just dishonest with respect to her status and ability to work. And the court upheld that summary judgment and said that that in fact that was a legitimate non-retaliatory reason. It did not violate FMLA. But the caution here is two things. One, Snyder is not a published case, so it is very much specific to the facts of that case and not a precedential decision. But second, there is a body of case law that says that surveillance of an employee on a protected medical leave, FMLA and CFRA, can be deemed per se adverse employment action, meaning per se interference with their statutory leave rights. And so you have to be very careful if this is an approach you want to take, if you have suspicion that your employee is in fact lying to you or, you know, committing fraud or something like that, and in fact can work without restrictions. I would recommend that you work with employment counsel before you hire a private investigator to go surveil your employee. And remember, though, that if you have reasonable suspicion, right, and credible information, you can take certain actions. You're allowed to recertify, which means you can require that person to go back to their doctor and submit a new certification because you have credible information that leads you to believe they're not restricted the way they're representing to you. So I think use those methods that are provided for employers within the parameters of the statute and the regs first before going and hiring a private investigator. But in this case, that's what the employer did, and the employer actually prevailed on that summary judgment. Okay. Another interesting case, the Munger versus Cascade Steel Rollings Mills case. This is out of a federal court in Oregon. And again, I'll give you some words of caution when I'm done talking to you about it. But essentially, the employer adopted a new policy that required employees contact a third-party FMLA claims administrator if they wanted to initiate a FMLA claim, and then of course work with that administrator to submit appropriate documentation, and then during the period of their FMLA leave to communicate with that claims administrator. And the policy said that merely submitting doctor's notes would not automatically excuse the employee and protect them under FMLA. So in this case, over a period of time, the employee submitted doctor's notes in 2015 for certain absences for his own health condition, what he claimed were serious health conditions, and also to care for his daughter. And he requested that those absences be treated as FMLA. The employer told him that submitting the after-fact doctor's notes does not excuse him, does not protect him under FMLA, and they counted those absences under an attendance policy, right, which is permitted under the FMLA regulations. In 2016, the employee then has a number of additional absences and emails doctor's notes to HR. And he's told, look, you have to contact the third-party claims administrator if you're telling us that you think you're entitled to FMLA leave. Otherwise, we're going to again count your absences under our attendance policy. And if you get enough absences under the attendance policy, then there will be consequences. And the employee failed to contact the claims administrator, and ultimately the Cascade Steel Rollings Mill terminates the employee. So employee sues saying, you're interfering with my FMLA rights. I submitted, sufficient documentation to put you on notice that the reason for my leave qualified for FMLA. That's all I have to do under the regs. And therefore I didn't have to contact the claims administrator. And there's a provision under the statute, 29 USC 2615A, that says it's unlawful for an employer to interfere with, restrain, or deny the exercise of or the attempt to exercise any right provided under the FMLA. And he argued that that provision said, if I've given you sufficient information that puts you on notice that I'm eligible for FMLA, you cannot deny my right to exercise my FMLA rights. But there's another provision under the regs, 29 CFR 825.303C, that says employers can require employees to comply with the employer's usual and customary notice and procedural requirements for requesting leave. And the employer pointed to that and said, this is our usual and customary notice and procedure requirements. You were notified of them previously and you didn't do it and got absence demerits. We gave you a chance, you didn't do it again. And we are allowed to take action if you don't comply with that. The case law supports the fact that an employer can take adverse action for an employee who fails to comply with those requirements. And it's very settled case law in the Ninth Circuit. So the court found that the employer's policy requiring that an employee work with a third-party FMLA claims administrator was not discriminatory and did not violate the FMLA, and upheld the summary judgment. Okay, that's it for me, guys. Happy New Year, and I'm going to pass you off to Megan.
Hello, everyone. I hope you are all doing well. Again, as Beth said, I'm Megan, for those of you who don't know me, and I am going to talk to you a little bit about reasonable accommodations, about discrimination, and about harassment. But first, we'll get started with reasonable accommodations. Like Beth said, with the leaves, not a whole lot of new updates in reasonable accommodations this year. So we're mostly going to talk about some cases I found interesting that kind of reinforce maybe some of our practices that we should be following, or some little bit warnings of some things that maybe we shouldn't be doing. So first, we have the Brown versus Los Angeles Unified School District case, and it's an interesting case. There was a teacher who, well, I should start with, the district had basically put in a new Wi-Fi system, a little bit more up to date, a little bit more, just technologically advanced system that they previously had. And a teacher found out about this when it was announced. The district said that you know, a lot of times when there's new technology, you might get some sort of warning that says, this could cause certain issues. It could cause chronic pain, headaches, nausea, those sorts of things, just because they probably had a lawyer who said that they should put those warnings on. So the district had put that warning out. She came back and said, hey, I am very sensitive to electromagnetic frequency, and I need an accommodation. I can't be around this new Wi-Fi system. The district said, yeah, that's not a disability. We don't need to accommodate that. So, and they essentially said, well, you can go on a leave of absence, we can separate your employment, but we can't accommodate this because, and we're not required to, because it's not a disability. The trial court said, yeah, that's not a disability, and granted the employer's summary judgment. Court of Appeal reversed. And I want to be clear, the Court of Appeal did not say sensitivity to electromagnetic frequency is a disability. That's still up for review. The case is still working its way through the courts. But what the appellate court said, hey, you did not take sufficient steps to accommodate the disability because you kind of ended it before determining whether that accommodation could be made. So what I want to note for all of you is the key takeaway here is the focus is not on, is this a disability? Courts do not want employers to play doctor. I'm not a doctor. Most of you aren't doctors, I'm assuming. That's not the focus of these accommodation questions. The focus is what's being requested, what is the accommodation, and can that accommodation be given? The focus is on that question, not the first question. And that's not to say there was never a disability that can't be questioned, but those are very fact specific. And if that's where your inquiry is going to be, I strongly suggest seeking legal counsel before going forward. Next, we have the Zamora versus Security Industry Specialist case. Mr. Zamora is, our security industry specialist was essentially a staffing agency. They employed Mr. Zamora and put him in different places, different employers, doing security work. So he, worked at Apple. He worked at some very large companies doing security for high profile individuals. He was doing his job one day. I think he tripped on a curb, twisted his knee, hurt a pop, had very clear knee injuries. The doctor said, okay, and he needs some time to recover from this. He can't do these things for about 2 months. It's fairly normal for a knee injury. He can't push or pull. He can't carry too much weight, things along those lines. The security industry specialist said, yeah, we can't accommodate that in your job. So you can check the job listings to see if there's anything else you might be able to do. Otherwise, we're just going to put you on leave. And didn't really provide him any additional information other than that. Mr. Zamora then went out on leave. And during that leave, Apple told security industry specialists that, hey, we don't need quite as many of this sort of position. Then I think they currently had like 19 and they were going to reduce it to 15. He, prior to the injury, had been ranked 16th out of the 19th individuals. And so security industry specialists, knowing that they needed fewer of his positions, said, okay, we're going to let the 4 bottom people go. So the RIF totally unrelated to the injury. In doing the RIF, they took the 2 individuals that were below him in the rankings and said, well, you're not going to be a supervisor anymore, but we'll demote you and give you essentially just a regular position. They did not do that for Mr. Zamora. And so, Mr. Zamora sued, and the trial court granted separate summary judgment in security industry specialist favor and said, well, the RIF was unrelated to the disability, and so it's good. The appellate court reversed and essentially said, you didn't really follow the interactive process. You can't just tell an employee, hey, go look at the job listings and see if there's something else that applies. You have a duty as the employer, who knows what the listings or various job opportunities might be, to go that extra step and say, hey, we have these open positions. Let's see if you have anything that might apply. And so they reverse summary judgment saying, you got to go to trial on this particular issue, whether or not there were other job positions available that Mr. Zamora could have done. So essentially what the court is saying, you can't require an employee to go on leave when a reasonable accommodation otherwise exists. And so that's the main takeaway you want to take from that case. Next, we have Wilkin versus Community Hospital of Monterey Peninsula. This was a case where there was a nurse who had some disabilities that were kind of in the background. I think she had Hashimoto's disease, and she had a couple of other things that that were known to the employer, but weren't necessarily things that were presently active, or it was just kind of in the background. There was about a period of a year where she had several written disciplinary notices for unrelated to disability issues such as poor performance, poor attendance, things along those lines. And then in November of 2017, there was an investigation that determined she had failed to properly document the administration of certain medication. During that investigation, they found that that had happened several times in the past. So on the basis of that investigation, she was discharged. He filed suit, said, hey, you can't do this. You clearly did this based upon my disability. This was a wrongful termination. The trial court dismissed, and the appellate court upheld that lawsuit, saying, hey, in order for you to prove that your employment was discriminatory, you have to prove that you were, basically doing your job in a competent manner. Here, we have 14 months of counseling notes saying that you weren't doing that, which was followed by an investigation, which is a legitimate investigation that determined you had wrongdoing. You can't prevail where the employer has shown that had a legitimate business reason for your termination. So here, what I want you all to take away is documentation matters. Here, the employer had 14 months of documentation that they could show the court and say, hey, we worked with her. We were trying to get her to a better place. She wasn't performing her job competently. If that, documentation didn't exist, it would be much harder for the employer to prove that there were performance issues that led up to the termination. Next, we have the Wirtz versus City of Newport News case. So here, Mr. Wirtz was a detective. He, this case I want to first note is out of the Fourth Circuit, so not necessarily a Ninth Circuit case that applies to California law, but I think that in a lot of ways, the California courts would find that in a similar matter. So I thought it was an interesting case for us to look at. He was a detective that had a disability, and he sought an accommodation that would allow him to continue performing his job as a detective. The city said, oh, no, you can't perform the essential functions of your job. And so you can either retire or you can be reassigned to a civilian position that Mr. Wirtz had said, yeah, I don't want to do that. And so he ultimately retired. The Fourth Circuit, after the district court had granted summary judgment in favor of the city, said that, no, we're going to reverse that. You're granting a summary judgment. You can't unilaterally reassign a disabled employee to a position that they don't want when another reasonable accommodation exists. So this is a very much a finding that was based on the specific facts of this case. There was evidence that Mr. Wirtz had suggested other jobs he might be able to do, and there was evidence that the employer hadn't properly, engaged in that interactive process to see if any of those positions existed that he would be able to do those job duties for. They just essentially said, yeah, you can't do this job, so you're going to have to either retire or accept this reassignment. And so what the court said was that when there are reasonable accommodations for the particular position that employee is in, you can't just reassign them essentially because it's easier. You have to do that reasonable accommodation analysis before moving towards reassignment to a position, especially where that position is not a position that employee desires or wants. And so I think that's a good thing to have in the back of your minds when you're doing this analysis, because a lot of times reassignment might be easier. But really, you have to first focus on the reasonable accommodation of that particular position before moving on to an analysis of whether or not there are other positions that might be available. So next, we're going to talk a little bit about harassment. This year we have we have SB 331, which adds further language to CCP 1001 about disclosure of in settlement agreements of sexual harassment, and it essentially extends it to discrimination harassment. So a lot of you might remember that in 2020 we had new legislation which said that you can't prevent or restrict the disclosure of information when you settle sexual harassment claims. And so it comes out of the Me Too movement. What the law essentially says is when you're settling a case that has either been filed with an administrative agency such as FEHA or in civil court, you can't, as part of that settlement agreement, require them to keep confidential the facts of that case. Prior to 2020, it's a fairly common practice. When you settle a case, there's a confidentiality clause. That's in a lot of ways one of the reasons employers settle cases. They get to keep it, essentially the information from being disclosed. What in 2020, when California Code of Civil Procedure 1001 said, you can't do that for sexual harassment cases. What SB 331 did was extend that to other forms of discrimination, harassment, and retaliation. So essentially any FEHA-based claim, when you're settling it at the administrative level or at the civil complaint level, you can't require non-disclosure of the facts of those cases. There is no language that states that you can't require confidentiality of the amount of the settlement. It strictly talks about the facts of those cases. So there are maybe some avenues you can do it prior to litigation. So when you get a pre-litigation demand letter or something along those lines. So if you do have get one of those demand letters, I would consult with legal counsel to see if there is a chance that you can keep the facts confidential, if it's something that you want to do prior to those administrative agency or civil complaints being filed. Next, we have SB 352, which so California's military code essentially incorporates the federal uniform code of military justice. It's something along those lines. And essentially the federal code doesn't restrict sexual harassment. It's just not something that's discussed. So what SB 352 does is amends California's version and says, yeah, you can't sexually harass people. And it brings it more along align with other restrictions of sexual harassment throughout the state. AB 1407 requires bias training as a requirement for nurses. So I think this probably doesn't apply to very many of you, so I'm going to move past it pretty quickly to save time. But essentially, within 2 years of a nurse receiving their nurse's license, they must complete at least 1 hour of implicit bias training through a board-approved employer or advisor. And so that's going to be similar to any bias training that's required of other employees. We're just going to end with discrimination, which we're going to talk about 2 cases and some updates to the EEOC guidelines. So first we have Pollock versus Trimodal Distribution Services. So here, Miss Pollock was a customer service representative. She had engaged in a dating relationship with the company's executive vice president for a while. And he had pressed her to have sex. She didn't want to, and so they broke up. And this case is really a case about it's kind of a legal case when someone has to file a lawsuit by. So I'm sure you're aware, for really any civil complaint you're going to file in California, there are statute of limitations you have to file or follow according to what's being claimed. And so here, the question was, did she file her lawsuit in time? And so what happened was, after she refused to have sex and broke up with the vice president, she claimed that she began to be passed over for promotions. And there was one particular promotion where she had gone up for it. And then in March of that year, the employer had offered the promotion to another employee. Ms. Pollock claimed she didn't know about that, and she didn't know about who had received the job or even if she had not received it till that May when the promotion took effect. He filed a lawsuit saying, hey, I didn't get that job because I refused to have sex with the company's executive vice president. You can't do that. The employer filed a demur alleging that, hey, this isn't a valid claim, that we decided to promote the other individual in March. Her lawsuit wasn't filed in time because it wasn't filed until May of 2 years later. And under the statute of limitations at that time, it would have had to have been filed by that March. So it essentially had missed the statute of limitations by 2 months. The court said, well, that might be true, but if she didn't know about it, then that doesn't apply. The statute doesn't begin to run until she became informed that she didn't receive that promotion. And so what the case is essentially saying is that when there is a failure to promote claim, the question is not when the failure to promote happened. The question is, when did the employee know or should have reasonably known that of the employer's decision? And so that happened in May when the new employee took the job. And so that's where the statute of limitations runs from. And so it's a very legalistic position that is just interesting. Next, we have Smith versus BP Lubricants. So here, Smith's employer was Jiffy Lube. They were having a new product that was going to be marketed. And so they had an employee of BP Lubricants who was going to come, tell everyone about this new Castrol product and let, everyone know how to market it. During that presentation of the new marketing, or the presentation of the marketing of this new product, Mr. Smith alleged that the Castrol employee, or who is Castrol is the DBA of BP Lubricants. So the BP Lubricants employee had made a number of discriminatory and inappropriate comments. And he found them to be racist, and he filed a lawsuit. He, in filing the lawsuit, filed against both his employer, which is Jiffy Lube, and BP Lubricants, which employed this the employee who was allegedly making the discriminatory comments. And so what Mr. Smith said is, we have FEHA. So the first thing he brought it under was a FEHA complaint, which we all know is an employer area of law. So he said, well, my employer, Jiffy Lube, essentially let the employee who was making the discriminatory comments, brought him in, made him so that he was able to harass me and discriminate me. Therefore, they aided and abetted him, which is, there's language under FEHA that lawsuits can be brought against employers when they aid or abet the discriminatory conduct. And so by bringing him in, they aided and abetted the discriminatory behavior that occurred. The court said, you haven't presented any evidence that your employer, Jiffy Lube, aided and abetted the discriminatory remarks made by the employee of another company. And so they allowed that claim to be dismissed against Jiffy Lube. However, they allowed the claims against BP Lubricants to go forward under the UNRRA Act, which essentially said the business establishment of BP Lubricants could face liability for comments their employee made to what's essentially a customer. And so it's an important thing to remember is that, you do have your claims against that you want to protect your employees, but how do your customers, clients, the people that your employees interact with on a daily basis, those could be subject to other claims, even outside the employment arena. They also allowed a claim for intentional infliction of emotional distress to go forward against BP Lubricants and that individual as well. Next, we did have some new guidance out of the EEOC regarding LGBTQ workplace conduct. And these essentially come out of the Bostick decision that came out of the Supreme Court last year. So as many of you will probably remember, last year, the Supreme Court, out of several consolidated cases where various employees had alleged that they had faced discriminatory conduct, wrongful termination, things along those lines. that their employers had acted that way against them because of their sexual identity and or sexual orientation. What the Supreme Court said was you can't take actions against an employee based upon their sexual orientation and or identity. You know, the decision's interesting in that the court specifically stated that their decision was based upon the facts currently presented to them, and that they specifically declined to make any determinations how they would rule should an employer, you know, for employers that might be a religious entity or things along those lines where there are religious implications based on the actions being taken against the individuals for sexual orientation and or sexual identity. So it's an interesting case, and then there was that little bit of a carve out. Regardless, the EEOC issued new workplace guidance and more in line with the Bostick decision. I think you'll find that as a California employer, a lot of these are already going to be guidance that you would be required to follow as a California employer, because they have been, sexual identity, sexual orientation have been protected classes under FEHA for quite some time. And so on the next page, you'll see where the guidance is. But essentially what the guidance says is an employer covered by Title VII can't fire, refuse to hire, take assignments away, you know, any sort of what would be classified as an adverse action against an individual because of their sexual orientation or sexual gender identity. They can't base what they're going to do based on a customer preference. So if you have a customer and says, hey, I don't want to work with that person because I know that that person's a lesbian, you can't do that. That sort of thing, which as a California employer would already be an employment practice that you can't follow anyway. There's regulations that say you can't prohibit a transgender person from dressing or presenting in a way that is consistent with that person's gender identity. And if you have separate bathrooms, locker rooms, or showers based on gender, you have to allow that person to use the restroom with the gender identity that they are identifying as. And so at the bottom, we have those where you can find those regulations if you want to look at them. But again, they're going to be generally consistent with what California employers require anyway. So that was a real quick kind of review of some new and interesting things in those arenas. And if you have any questions about them, let me know. Thank you. And I want to say Brendan's next, but I could be wrong on that.
Yep, I'm next, and here I am. Thanks, Megan. And thank you, everybody, for coming today. I'm here to talk to you about retaliation first, and then NLRB issues. I'm trying to get control of the screen here. There we go. Retaliation claims first. So listen, those of you who've come to my presentation on this before, you're probably tired of hearing me talk about it. You know, it's like we all hear these people screaming about how serious COVID is, and we know it is, right? And so sometimes we feel like we want to hear something else. You know, retaliation claims are very serious, but unlike COVID, which I think, you know, we already have some vaccinations, presumably they're going to get better, and someday, you know, it's not going to be that big of a concern. Retaliation claims are going to continue to be a concern for years. They've just been on the increase. Look at these statistics. You know, I'm not going to read them to you, but you know, it shows that they're just going up and up. Now, granted, for the last few years, the number of retaliation claims has come down just slightly, but I think that's a false sense of security that shouldn't be embraced, because even though the number of claims have come down, retaliation claims remain the #1 kind of complaint that's filed and handled by the EEOC, the federal agency that handles discrimination, harassment, and so forth. Not only is it the #1 kind of claim, it's in over half of all the cases consistently. It makes up half of the claims, if you will. The amount of money that the EEOC has recovered for retaliation claims continues to go up. It has not dipped, and last year it, you know, set a record of $214.9 million, and that's up from, you know, $140.5 million in 2014. So look at, how much it's going up. It's, that's the big concern, right? It's not how many retaliation claims you get, it's how much they're costing you. And so, I think we're going to continue to see retaliation claims go up, even though, as you'll see, some cases have come out that have sort of hit the brakes on them a little bit. Now, these figures that I'm sharing with you don't even include private lawsuits. Private lawsuits, I would bet you probably quadruple that $214 million number. Just my guess, because the EEOC doesn't always resolve this stuff. More often they issue a right to sue notice and people go off and sue and then recover that way. So why do they continue to increase? Why are they continuing to be a threat? Well, partly because they're so easy to prove, and also I would add they're so easy to identify with. They're easy to prove because there's just really few simple elements that the employee has to show. They engage in protected activity. Look, they complained about harassment or discrimination. They complained about something unlawful happening. They participated in an investigation about somebody else's complaint. You'll see a slide later on here in my presentation about some indication that refusing to participate in an investigation is not protected activity. Well, okay, that's according to a federal court in a different area. I would say let's not try this at home in California unless we have to. Refusing to participate in an investigation may be protected activity. We'll talk about that in a little bit. So, okay, they engage in protected activity, a lot of ways to do that. They suffer an adverse job action. They get fired, demoted, transferred, assigned job duties that are less desirable, excluded from meetings, you name it. Adverse job action happens all the time, happens every day. Okay, then there's some causal connection between the two things, the protected activity and the adverse action. Look, if it happens within a year, if the two things happen within a year of one another, causal connection probably established. And then that shifts the burden, to the employer to provide a legitimate explanation for what it did. Most of your jurors are going to be wage and salary earners, not managers and business owners who appreciate managerial goals and things that need to be done to keep the business afloat. And so they're probably going to be maybe more inclined to find that the explanation wasn't believable and hold the employer liable for retaliation. So what? A lot of people get sued, winds up, they collect a lot of money. How much money can they really get from one employer? I'm here to tell you a whole lot. Look at this case from Los Angeles just a month ago, right? A jury awarded this former insurance company executive $5.5 million for just routine damages, okay? But $150 million in punitive damages. Now, between you and me, that number is probably going to come down because courts have said that punitive damages cannot exceed 10 times compensatory damages. But wow, just look at the compensatory damages, $5.5 million, emotional distress. A jury has got a lot of ability to figure out how much you'd have to pay them to endure that, indignation every day, $10 a day, $100 a day, $1,000 a day. Okay, so look, these claims are problematic. They're common, they're easy to prove, and they can lead to big money damages. So luckily, some murky standards are likely to become clearer. They weren't so clear in 2021, but here early in 2022, they're likely to become clearer. The California Supreme Court is set to issue an opinion probably by early February. Could come earlier, could come any day now, to define, what are the standards of proof in what we call an 1102.5 claim. That's section 1102.5 of the Labor Code. This is the anti-retaliation law that basically says if your employees complain to a government agency, not necessarily about discrimination or harassment, but about really all kinds of other things. You're not following government regulations, you're breaking the law in some way, you're cheating your customers, you're not paying wages properly. All these kinds of things can be 1102.5 claims. If the employee complains about it, what's the standard of proof here? Another kind of 1102.5 claim, the employee refuses to do something illegal, says, no, I'm not going to go do more deliveries because, I had a drink and I'm a delivery driver, so I'm not going to go out and do more deliveries, and he gets fired for not doing his job. Well, he wasn't allowed to do deliveries if he had a drink, under the law. So that firing was unlawful. So what happens with the burden of proof? Well, right now it seems like the employee has to prove all the way through, all the elements of a retaliation claim. But there is some modification to this statute that suggests that the employer has a burden of proving by clear and convincing evidence that it took the action it took legitimately. And there's some debate about whether or not that comes later on, only after the employee has already proved it was retaliation, and the employer has to prove, well, there was some other reason that it would have been the same result. Or does the employer have to prove that in the main case? If the employer has to prove that in the main case, I'll tell you what, as many retaliation claims as we've been seeing, I think they're going to go way up, and the monetary recovery for such claims is going to skyrocket. So let's see what the California Supreme Court does. We're going to find out pretty soon. The case is Lawson v. PPG Architectural Finishes. So, okay, what about managers? Are managers protected? Well, if a manager is in the HR department and is assigned to respond to, complaints about discrimination and harassment, normally they can't turn around and sue. If they get fired for not doing their job, they can't sue and say, well, I was retaliated against because I was handling retaliation and discrimination claims. Well, that's because that's their job, and so you can't, if you do your job well, you keep it. And if you don't do it well, you get fired, but it's not retaliation just because that was part of your job to handle these kinds of complaints. And a federal court in, the sort of Midwest, sort of the East, covers Kentucky, Michigan, and Ohio and Tennessee, said, yeah, she might have been engaged in protected activity. Even though the normal rule is she's not, this case said, yeah, maybe she was, probably because she recommended changes to the employer's policy, didn't just handle this discrimination, retaliation, harassment complaint, but recommended changes to the policy. And she gets fired for making recommendations like that. She's actually advocating, for worker rights, and maybe that could be a wrongful termination. However, the court really based the decision on what standard, what set of laws govern that. So we don't have a clear answer yet. And this is a different state, but it's something to look out for. So if you're thinking about firing somebody who does HR, who handles discrimination and retaliation and harassment complaints, really talk to a lawyer before you do that, because there are new developments all the time. Okay, what about refusing to participate in an investigation? I told you this in my introduction. According to a federal court that oversees cases in Maryland, Virginia, and West Virginia, and North Carolina, South Carolina, way over there on the East Coast, where they look at things a little bit differently than California, they said, well, if you complain about something, but then you refuse to participate in the employer's investigation about that complaint, guess what? You can be fired for that. Refusing to participate in the investigation is not protected activity. And that is pretty common sense. And so, you know what? That could transport to California rather nicely. Again, though, I say, let's be careful about trying this at home. In this case, it wasn't really a harassment or discrimination claim, so you could distinguish it from Fair Employment and Housing Act or Title VII kinds of claims. Not only that, but I can easily imagine California courts saying some kinds of refusal to participate in an investigation could be protected activity. If, for instance, you think that the person conducting the investigation is a harasser and you don't want to be around that person, okay? That could be protected activity. This one kind of half-baked example, but again, if you're thinking about firing somebody for refusing to participate in an investigation, my recommendation also is, let's talk to a lawyer first and think it through. Another federal court. All these cases, by the way, are from federal courts. California didn't have a lot of, really momentous appellate decisions in 2021 regarding retaliation. In a way, that's good. It kind of says, well, now we kind of know what the ground rules are. And another way kind of means, yeah, they're as bad as they were before when we had, more and more retaliation claims and more retaliation numbers, payments, if you will. So what about a decision maker who's unaware of the protected activity? You know, this can work. This is what we call the cat's paw theory. So let's say I have discriminatory animus and I want to get Megan or Beth or Ryan or James fired. And so I complain about them and I tell the decision maker all kinds of stuff about them, you know, that is wrong. I'm their supervisor and I tell my boss, hey, these are not a good employees and they did all this stuff wrong, so fire them. And that decision maker fires them. Well, then there's this cat's paw theory where they say, even though the decision maker didn't know about, you know, the bias that I had, he was just the cat's paw because he based his decision on everything I said. It was all based on my information. Well, here, this federal court that oversees cases in Illinois, Indiana, and Wisconsin said the cat's paw theory doesn't apply if the decision maker bases it on information that is corroborated independently of the, you know, discriminatory supervisor who, you know, launches the investigation. That again is also another pretty common sense application of the rule, I would say, but I question also whether this would fly in California, unless, you know, it makes it easy for me to imagine it would be hard for California to throw a case like it's out at summary judgment. They'd probably say a jury needs to determine whether or not the, you know, independent decision maker was overly influenced by the information I gave him, even if he went out and corroborated it somewhere else. You know, my participation in the thing at all might have tainted the whole process. So I'm not saying that definitely would be so. Again, I'm just saying, you know, you might have some arrows in your quiver here, but talk to a lawyer, I would say, before you sling them. Now, seeking legal advice should not lead to liability. This was the only California case that I thought was worth reporting. And so in this case, pardon me, let me get a drink of water. In this case, you know, the trial court allowed the plaintiff to question the defense witness about why they sought legal advice just 2 days after, you know, the plaintiff complained about something, but, you know, very shortly before firing the plaintiff. And, you know, the Court of Appeal said, no, you can't let them question that because, you know, that stuff is attorney-client privilege, number one. And number two, you know, because the witness probably can't answer a lot of those questions, it can lead to the improper inference that they were looking for, you know, advice about firing this person because they knew it was wrong. And so if you seek advice from an attorney about this, you're not going to be in California questioned on the stand about why did you call an attorney about this? I'd say all the more reason to call an attorney when you're thinking about, you know, firing somebody who's engaged in or arguably engaged in the protected activities we've been discussing. Okay, so that's retaliation in the nutshell. Last thing I want to say about it is, you know, you want to talk to a lawyer first because you don't want to wind up in front of a jury. Juries really empathize with retaliation claims a lot more than they do other kinds of claims because they're so easy to identify with. You know, not very many of us have been treated, well, maybe too many of us, but not all of us have been treated differently on the basis of our race, our age, our gender, our disability status. And so it makes us, you know, kind of skeptical maybe sometimes of such claims. We're really going to have it proved for us that such things happened because we wouldn't do something like that and we haven't experienced that ourselves. But with a retaliation claim, who hasn't been subjected to discipline by the boss because they did something that the boss didn't like, right? That's an easy claim to identify with. So let's take those claims seriously and call a lawyer. National Labor Relations Act. That's what governs the National Labor Relations Board. It mostly governs union employers who have unionized workforce. And so a lot of you might be thinking, well, this doesn't apply to me. But it does in a way because the National Labor Relations Board also handles claims about employees who say, I was fired because I posted stuff on Facebook about my employer, or I was fired because I shared information with my coworkers about my pay, my benefits, the assignments that I had, what the managers told me about things that were going on at work. And so, this stuff can apply to you. I would say, maybe not as serious as retaliation claims, but serious. The NLRB collected what, 53, almost $54 million in back pay awards compared to the 219 million that we're talking about the EEOC got for retaliation claims. So just a small fraction. And the EEOC handled, how many hundreds of thousands of retaliation claims, whereas here the NLRB handled what is about 6,300 employees. So it's not as drastic, but these numbers are going up. And so it's also something to, not shrug off so easily. So, the NLRB has done some things that its composure has changed, and it has done some things that suggest it's going to have a ripple effect on even non-union employers. And so, it's going to be likely more aggressive in trying to advance employee rights rather than looking at the management employer perspective. And I'll explain that. One thing, that's contemporary is what it's doing with vaccination stuff. It says that vaccination mandates are not subject to union negotiations. So if the employer, a unionized employer, says you all have to get your COVID vaccine, that's not something that the union can negotiate. However, the union can negotiate things about how they're going to implement that. So are they going to have to be on the job when they get the vaccine? Are they going to have to get a day off after they get the vaccine, a paid day off that doesn't count against their sick leave because this is something that, their employer made them do? These kinds of things maybe are things that the employer is going to have to negotiate. Now, why are we thinking that, it's going to be a more aggressive NLRB? Well, because now Democrat appointees make up 3 of the 5 slots on the National Labor Relations Board. And so as a consequence, a lot of folks think that means the NLRB is going to be more aggressive advocating for employees and not so sympathetic to managerial perspectives and ambitions. Another reason is the NLRB has a new general counsel, and she has issued a memo that really outlines how ambitious she intends to pursue her new role, how ambitiously she intends to pursue it. She's going to revisit many Trump era decisions that were more favorable to employers. And so all that stuff that you might have thought was pretty well established over the last 4 years is now maybe up in the air. This new general counsel also issued a different memo where she says, she's going to be more aggressive in seeking injunctive relief. What does injunctive relief mean? Well, it means she's not only going to say, hey, give these people back pay who you wrongfully fired for posting things on Facebook, for talking to other employees, for trying to organize a union, for advocating for better terms than next contract. We're not only going to make you pay back pay for that, we're going to have courts order you to assign them to different positions, to give them different job duties, to get rid of policies that you might have had that might affect such things. So getting injunctive relief for, as opposed to just, back pay or money damages, that can really significantly impact the workplace and the employer's ability to carry out its goals. Another reason, the NLRB has telegraphed its inclination to consider expanding remedies from not just back pay, but to also include compensatory damages. What does that mean? Well, it could mean emotional distress. Right now, if you fire somebody for engaging in protected activity that's protected under the National Labor Relations Act, you have to hire them back, you just pay them back pay. But now, maybe you have to pay them emotional distress on top of that for, being wrongfully terminated. So they haven't done it yet, but they've signaled the inclination that they're kind of heading in that direction. Another reason to expect it is the general counsel has indicated that she's going to, really advocate for the idea that college athletes are employees, not just students under the National Labor Relations Act. And so the College Basketball Players Association filed a charge with the NLRB already, and it gives the NLRB an opportunity to explore this, new way of looking at who is an employee and who isn't. So if you're, not a college that has these employees, that decision itself might not impact you, but it could have ripple effects. And it definitely telegraphs that the NLRB is going to be a lot more aggressive in pursuing these things. Now, the last thing I have to say about the NLRB is a federal appellate court told the NLRB to reconsider union activity on private property. In this case, a bunch of musicians went, to perform. They were expected to perform at some venue that was owned by somebody other than their employer. And, they went there and they circulated leaflets and this and that and did different stuff. And that the owner of that venue took some, reprisals, if you will. And the NLRB, under, the former composure where it was more Republican than Democrat appointees, said, no, that's okay. They can't be expected. The owner of that venue can't be expected to let employees from some other unionized employer picket or demonstrate or circulate leaflets there. But the DC Court of Appeals there in Washington, a federal court, said, we think the NLRB has to reconsider that. So we don't know what the new rule is yet, but this could affect you because you could be, an owner of some property that's not unionized, but you might have to let employees from other unionized employers conduct activity on your grounds. So we'll see what happens there. But I think that brings my presentation to a conclusion. I hope you don't all feel the sky is falling, but I hope that this helps you avoid these kind of problems, inoculate yourself against NLRB problems and retaliation claims. All right, with that, I'm going to hand it over to James.
Thank you, Brendan. Good morning, everyone. I'm James Kachmar. I'll be talking about issues involving employment agreements and then turning to non-compete provisions and trade secrets. Once again, like I do every year, it's my job to get us back on track time-wise so that we can finish at 11:30 and get everyone out to their lunch periods. Starting with PAGA claims. Again, employers really want to try to get as much as they can into arbitration as opposed to letting employees file lawsuits. Those of you that were at last week's presentation, PAGA would have been covered. Typically, it allows an employee to stand in the shoes of the state and bring claims for violations of the labor code against an employer on behalf of themselves and others. In 2014, the California Supreme Court in Iskanian held that you cannot require arbitration of PAGA claims. And then 2 years later, the US Supreme Court in the Epic Systems case held that the FAA preempted state law that prohibits arbitration of class actions. So that's kind of the background that leads us to the Viking River cruises. Once again, an employer is seeking to enforce an arbitration provision that includes PAGA claims, arguing that under the US Supreme Court's decision in Epic, it has essentially overruled the Iskanian decision by the California Supreme Court, and that PAGA claims should be able to be subject to arbitration claims. The US Supreme Court has agreed to consider the matter. It'll now schedule briefing and oral arguments, and so we expect a ruling in this matter either late this year or more likely early next year. And if the Supreme Court finds in favor of the employers, basically it'll be finding that the Federal Arbitration Act preempts any state law that bars the arbitration of PAGA claims. So this could be array of hope for employers if the US Supreme Court agrees with Viking River Cruises and says that you can't bar these types of arbitration agreements. We talked about this last year, AB 51. This was a law that was passed in California in 2019. It prohibits the use of arbitration agreements. That's what it's targeting as a condition of employment. And it was to apply to employment contracts entered after January 1, 2020. Almost immediately, the U.S. Chamber of Commerce filed a lawsuit in federal court to challenge it. And last January, a federal court here in Sacramento agreed to enjoin enforcement of AB 51. Basically, the court found that the Federal Arbitration Act preempted this area of law, meaning that California couldn't pass its own law contrary to the Federal Arbitration Act. And so it stayed enforcement of AB 51. California appealed to the Ninth Circuit, and unfortunately in September, a divided panel voting 2-1 found that AB 51 can be enforced, that it was not preempted by the Federal Arbitration Act, although the court did find that the imposition of civil or criminal penalties as called for under AB 51 would not be allowed. Nevertheless, it reversed the trial court and ordered that the preliminary injunction barring the enforcement of AB 51 be reversed. The U.S. Chamber of Commerce immediately filed a petition for rehearing by the entire Ninth Circuit. That means a request that the entire court hear this appeal. We are still waiting a ruling on that petition. It's also our understanding that if that petition is denied, the U.S. Chamber will likely appeal the decision to the U.S. Supreme Court. So as a result of the petition for rehearing, the Ninth Circuit's ruling is currently stayed. And so basically the trial court's rule that you cannot enforce AB 51 is still in effect for now. But again, employers should be cautious here and continue to monitor this situation because if the Ninth Circuit's ruling is upheld either by the entire court or by the U.S. Supreme Court, then once again, employers are going to face exposure if they're requiring arbitration agreements with their employees. Earlier, there was a brief mention of Senate Bill 331. Once again, 3 years ago, the California legislature enacted a law largely in response to the Me Too movement that prevented confidentiality agreements and certain settlement agreements of claims of either sexual harassment, sexual discrimination. And that took effect in 2019. The new Senate Bill 331 now expands those restrictions to include any type of discrimination or harassment, not just based on sex. So it could be racial discrimination or any other protected class. You can still keep the amount of settlement and the identity of the claimant confidential. You just can't bar disclosure of the facts that supported the claim of discrimination. And then one other thing SB 31 does is that if you have a non-disparagement agreement in your settlement agreement or severance agreement saying, each side agrees they're not going to badmouth the other, that non-disparagement provision must include a disclaimer that it does not bar the disclosure of facts as to the alleged unlawful acts of the employer. And this went into effect about a week and a half ago. It applies to any separation or severance agreement or settlement agreement that's entered into after that date. And so those of you that are just printing out old severance agreements and maybe changing the names, the amounts paid, you really want to review your old agreements or form agreements to make sure that they're going to comply with the new SB 331. Turning now to covenants not to compete and trade secrets. There's not a whole lot of new developments here, mainly on the non-compete side, so I'll move quickly through this. those of you that have attended past seminars, you know, we always tell you the general rule is that non-competes on employees are almost always unenforceable. This means you can't tell them that they can't solicit your customers or their coworkers after they leave your employer or leave your employee. The three exceptions all are within this bundle of where there's the sale of a business, then you can have a lawful non-compete. But it's only with the seller. It's not in the employee context. And so where a non-compete provision falls within one of these exceptions, it will be enforced by a court. And then, you know, in 2008, the California Supreme Court held just about all non-competes are unenforceable. Again, there are other states that do recognize enforceable non-competes. So if you're hiring employees from other states, you need to be aware that they could be subject to a enforceable non-compete from the state where they're traveling from. The President Biden has been under some pressure to explore the wide use of non-competes. This won't have much effect in California since it's already prohibited. But in July, he announced and signed an executive order. And it was basically asking the FTC to consider issuing rules regarding the use of non-competes. I put, remember Jimmy John's. Jimmy John's is a sandwich shop franchise, and they were in the news a year or two back in that they required all their employees to sign non-competes. So a minimum wage employee who gets hired to make sandwiches, if he or she leaves that job and goes down the street to Subway, arguably would be subject to a non-compete provision, and that provoked some outcry, and this was the Biden administration's response to some of that outcry. Again, it has no immediate legal effect. It just instructs the FTC to consider making rules. Fleming versus Matco Tools Company or Corporation. This was a misclassification case, but the plaintiff also alleged a violation against the defendant employer of Labor Code section 432.5. And that section allows for an employee to seek civil penalties against the employer for requiring an employee to sign an agreement that is prohibited by law. And so in this case, all the employees signed employment agreements that had standard non-compete provisions, which are not enforceable under California law. And so their claim was there should be civil penalties imposed on the employer for doing that. The federal district court dismissed this claim. And it did so on the analysis that while non-competes are void and unenforceable under California law, they are not necessarily prohibited by law that would provide the basis for civil penalties under this particular labor code section. So I will caution, there are cases out there that have held that using unenforceable non-competes can be an unlawful business practice that could result in injunctions stopping you from using those agreements. But at least this, again, shows a court unwilling to punish an employer with civil penalties for using them. Non-competes and independent contractors. Again, we usually talk about 16600 and the ban on non-competes in the employment context. Last year, we updated you on the Ixgel pharmaceutical case. This was a business-to-business agreement that had a non-compete. It was two pharmaceutical companies. They were jointly developing a new drug. And they had an agreement that said if the joint venture falls apart, you agree you're not going to pursue this line of drugs with anyone else. Of course, the agreement fell apart. One of them tried to manufacture the drug with a new partner, and they claimed that this non-compete barring them from doing so was unenforceable under 16600. And the California Supreme Court said, no, we're not going to apply 16600. That's strictly to a business-to-business scenario. and we will enforce them provided that they satisfy the rule of reasonableness. So the court was distinguishing between employment agreements, essentially, and business-to-business agreements. And why is this important? Because it takes us to the New Life Ventures case. This involved a multi-level marketing company. Some of you may be familiar with them. Think Amway. Basically, it's a sales company in which you recruit people to sell the products. If I'm recruited into the company by my friend, any sales I make, that person gets a part of the commissions from my sales. That's the upline. And if I recruit people to come in and do sales under me, then I get a portion of commissions from their sales. That's the downline. And this multi-level marketing company or MLM company had an agreement that an agent, once they left this arrangement, wouldn't solicit any of the people in either the upline or the downline to join them at a new MLM company. After some agents departed, they were sued, and the MLM company sought to enforce this non-compete provision against its former sales agents. They argued that this non-compete was barred by 16600, and the MLM company said, no, this is more of a business-to-business arrangement like the pharmaceutical companies in the Excel case. Notably, all the sales agents, rather than being individually signed up to this MLM, would form one-person LLCs, and that's who the agreements were. The court rejected this position and found that even though they were independent contractors, they were more like employees in this context, and therefore 16600 would apply and the non-competes would not be enforceable. Turning briefly to trade secrets, again, there hasn't been a whole lot in this area. We've told you in the past, trade secrets under California law is that business information, whether it's a formula, a program, a device, that has some independent economic value because it's not generally known to the public at large or your competitors, and that you've taken reasonable efforts to maintain their secrecy. A few years ago, Congress passed the Federal Defend Trade Secrets Act, which also now made it federal law for trade secrets. It's nearly identical to the California version as to what a trade secret is and how to enforce it. And some examples to think about as to what a trade secret is: the formula to Coca-Cola, the Colonel's secret recipe to Kentucky Fried Chicken. For most of you, your protectable trade secrets are going to be that information that's most valuable to you, and that's going to be, most cases, a customer list. Your customers are your lifeblood for your business, so how the efforts you've taken to create your customer list, your customer basis, and how you protect that information, that would be your protected trade secret. Where we see some interplay is between non-competes and trade secrets. And in the ESI group case, the plaintiff employer sued former employees or a former employee that was competing with it, alleging breach of contract and trade secret misappropriation. That former employee's employment agreement had contained a non-compete provision, but it was a very limited non-compete. It basically said, you will not use our trade secret information to solicit our customers or employees. And so the employee naturally said, hey, this non-compete violates 16600 and should be unenforceable. The court disagreed, and it said, if it was just a non-compete that said you will not solicit our customers and employees for a one-year period, that would likely be unenforceable. But the court noted that other courts had recognized a trade secret exception to 16600, and therefore would enforce a non-compete necessary to protect trade secret information. There is some split out there between the courts whether such an exception really exists. In fact, the California Supreme Court in the Edwards case said that there was no such exception. You basically had a trade secret claim or you didn't. And so The only caveat here is that to take advantage of this so-called exception, make sure that if you are including a non-compete provision, that it be limited and directly tied to the use of trade secret information, because that'll make it more likely to be enforced. And I've worked with several clients over the years to make sure that if they want a non-compete, that we draft it as narrowly as possible to try to fall within this narrow exception. So that is all I have today. I thank you, wish everyone a happy new year, and I will now turn it over to Ryan.
Thank you, James. Thanks for saving me some time there. I appreciate that as well. I'm going to try to get through some of these last pieces and hopefully leave some time for questions and answers as well. So that's coming shortly. Let's start here with employee privacy rights. Now, we're kind of looking ahead here with this, fortunately. And so don't be too scared when I go through some of these regulations that are going to probably shock some of you. But this is the CPRA, which is coming into effect on January 1st, 2023. There are some repercussions of that. There's some retroactive document requests that employees can make that make a lot of this relevant as of January 1st of this year. But again, on January 1st, 2023, California will in fact become the first state to have this comprehensive data privacy law covering human resources data when the California Privacy Rights Act becomes operational. And this is going to make, sweeping changes essentially to the California Consumer Privacy Act, which you had a crash course on just last year, the year before. And while most employees' rights we'll be discussing won't go into effect until 2023, like I said, you'll have time to ramp up. But a lot of the kind of document retention stuff is going to, like I said, is already currently operational. There's a limited HR exception, as some of you might recall, and this is not necessarily HR, it's human resources broadly means employees. That sunsets on January 1st, 2023. So that's regarding the CCPA, which is a sister legislation to this new law. As far as what companies are going to be regulated by the CPRA that we're going to get into here, it's mostly large companies will be affected, but also any company that really deals with the managing or handling or exchanging of personal private information of the consumers. At its heart, the CPRA is meant to regulate companies' use of consumers' data, users' data, things of that nature. But it also has a large implication on employees because it covers basically all California residents' private information and regulates the extent businesses can use, handle, and to what extent they need to provide information about what type of data they're collecting. But any company that grosses over $25 million will be automatically regulated. In addition, even if you gross less than that, a company that buys or shares over 100,000 or more consumers or households' private information, they're regulated. Or if the company derives 50% or more of its revenue from selling or sharing California residents' private information, then you're going to be under the umbrella and coverage of the CPRA. Which makes sense because, it shows your business is essentially that of data sharing. And in addition, any company that kind of owns or is owned by these types of companies could potentially be regulated as well. So I want to talk about essentially the four big requirements that, or we'll call it employee rights that the CPRA will give. And it's the right to delete, the right to know, the right to correct, and the right to limit the use and application of their private information. So here we're going to start with the right to delete. This is a new concept for employers here in California because generally we keep records we want and we keep pretty much as we can subject to our deletion policies. But here, this is going to give employees the right to delete certain types of private information that we keep in our records. And businesses must also, under the CPRA, notify service providers, so third parties, of a consumer's request to delete their personal information. So that sounds a little daunting, but there's three main exceptions to this, and a collection of exceptions that will significantly limit this right to delete information. The first is that it only applies to information collected directly from the individual. So a lot of kind of onboarding, application type things that the employee provides about themselves. So it applies to that. So it wouldn't necessarily apply to information collected about the employee, right? So for instance, evaluations or performance reviews might not apply to the extent they don't, fall outside those parameters. In addition, the right to delete doesn't apply to information if that private information is needed to comply with other laws. And in California, we have a lot of other conflicting laws that require us to keep and not delete certain information, even if it is potentially private. So that's kind of a way out. The third big one, as I see it, that's going to limit an employee's right to delete information is that employees or employers can refuse to delete information that would prevent the employer from defending itself against a legal claim. And, we all know to what extent anyone who's been involved in a document production during a lawsuit is very aware of the types of documents that could potentially become relevant in a dispute. And that includes everything from, wage information, hours worked and type of wage and hour class actions. In addition, complaints and investigation notes that include private information very well might become relevant. So, there are some limitations here. And in addition to these three, there's at least a dozen other bases listed in the statute that an employer can deny a request to delete private information. I'm not going to get into those, but you all have a year to catch up on that. In addition to the right to delete is the right to know. And this is, they say right to know, but it's essentially a right to request. So think of the document request that we're all familiar with. Upon an employee's request, the employer must produce within 45 days all the employee's private information that the business has collected. And private information under the statute is very broadly defined, and it may even include records that are kept by third parties that the employer might contract with, for instance, payroll companies or security companies. It can include things like biometric data, and wage data, things of that nature. But again, this looks a lot like the existing employee records request obligations that we keep, but it's a lot broader in many ways. And this will require better and more clear retention policies. We'll discuss more in a moment. The CPRA provides objections that employers can make. So for instance, if a request comes, an employer can object and say, I'm not going to produce these records because this is harassing or kind of overbearing. Basically, they can object on the grounds, as the statute says, that the request is manifestly unfounded or excessive, in particular because of their repetitive character. You could think if employees, for instance, required to sign or put their private information on every contract they sign, and they sign, hundreds of them a week or a day, you can see how that can become very excessive and hard to collect. The third right that an employee has under the CPRA is the right to correct their private information as it's kept on the records of the business. And this only applies to objectively false information. So they can only correct objectively false. They can't go back and rewrite what they would prefer to be in the records. So for instance, you could see how this would play out a lot in, like, for instance, addresses. Someone moves, they have the right to correct their address information in the company records. It doesn't apply to subjectively false information. So if an employee disagrees with an evaluation or with a complaint from a coworker, that wouldn't apply to this right to correct. In addition, there's a materiality limitation. So going back to the address hypothetical, if someone wants to correct their address, they could very much, have a right to correct the address on the, the HR website and applications so that, they're paid correctly and that they receive communications from the company correctly, but it wouldn't necessarily require the company to go back and correct all of those address references and prior email communications, because obviously it's materially insignificant. It won't affect anything. And the third is the right to limit. And this is basically the employees, in some instances, will have an opportunity to opt out of sharing their private information and the use of automated decision-making technology. And again, a lot of this, we're going to talk more in a moment. A lot of this is still yet to be fleshed out by some of the agencies. It's not entirely clear where these lines are, as is true of most, most new statutes, especially statutes as large as this. But from the onset, when information is collected from an employee, the CPRA requires the employers to provide a notice at collection. This applies to job applicants, employees, independent contractors, wherever that's private information is being collected. It has to explain the types of private information that's being collected, the purpose it's being collected, or the purpose for which it will be used, and any other criteria that's used for determining that. It also has to mention whether the company will also have to mention whether the business intends to sell any of the private information and provide a notice of the rights to opt out of selling that information. This obviously applies a lot less to an employment situation than it would to the general target crowd of the CPRA, which is consumers and users of websites and things. And then the business also is required to furnish a compliant privacy notice. And, a lot of this will overlap your notice of collection, your privacy notice to employees. It'll be important and useful for employers to streamline and to compile a lot of this information so that they're, uniform and that they don't contradict each other. And that when these requests come, it'll be a little more simple. I'm sorry, I'm moving fast here. I'm not going to go through a ton of these, but we're going to prepare for CPRA compliance before 2023. This is just a list. You can look at these. You're going to receive a copy of this PowerPoint presentation, and you could go through and look at these yourself. But the one I mentioned, I want to highlight here for the sake of time, is this fourth one with third parties that it's the CCPA will prescribe certain clauses to appear in agreements with third parties. So, I mentioned before, there's a lot of, biometric data being collected and other things of that nature. So this new legislation will require that this handling of this type of information is clarified and regulated in the contracts between third parties. And obviously, like most statutes of this nature, employees can't be retaliated against for exercising any of the rights we've discussed. But again, no requests can come under this until 2013. This year, while you're preparing, let me see if I can go back here. We want to evaluate whether and to what extent you process sensitive personal information. So understanding to what extent the company will be regulated, and looking at, for instance, geolocation software could even apply. So I know some companies, where they have a workforce that's, for instance, maybe driving around the state, they want to keep track of where those employees are for various reasons. So that could be considered sensitive personal information under the statute. So, again, you want to start looking into the universe of personal sensitive information that we're retaining, how it's used, where it goes. And then, in addition, the sensitive personal information includes government identifiers like passports, financial accounts, payment card numbers. This is just a list of some of the things that would apply. That again, previously we weren't necessarily keeping as private as we will be required to in the future. And I touched on this, as is often true of most new legislation, much of the CPRA is still pretty unclear. The California Privacy Protection Agency will hopefully clarify requirements when it promulgates its CPPA regulations in July of 2022. We expect that to be the case. And again, the CCPA, which we covered in our last year's seminar, currently requires a 30-day notice and cure period compliance enforcement without delay, but without delay begins in July 1st, 2023. So that's going to be another change in that statute. The CCPA will have authority to impose fines for violations of this new statute up to $2,500 for each violation and up to $7,500 for each intentional violation. So beware of that. And, you know, this could be a new avenue we're going to see for litigation from employers, from the employee bar, but we'll see. Next, we're going to quickly go through a case that recently was published last year on the issue of social media. And this is through the NLRB. I know we heard a little bit about that previously, but this touches specifically on the extent to which an employer can limit employees' use of social media. So this is actually a Sacramento case, Medic Ambulance Service, and there was an employer policy in their social media guideline in the handbook. It banned inappropriate communications, even if made on your own time using your own resources. So some of you might have winced at that because, you know, sometimes to the extent, you know, we can an employer can limit, you know, off-duty conduct has been in question. So there was an administrative law judge that reviewed this and in fact, you know, found that this did in fact violate the National Labor Relations Act. And as many of you might know, the National Labor Relations Act, you know, covers things like protected concerted activity, employees' rights to voice their concerns about their working conditions and things like that. The ALJ said this social media restrictive guideline clearly violates that. But the NLRB disagreed and finding that employers could in fact enforce carefully constructed prohibitions that seek to address legitimate company interests and not to interfere with employee rights. So here are, you know, some pretty significant, significant rulings, and these are the provisions that the NLRB found that are lawful under the NLRA. So the first few aren't too surprising. Employers can limit the disclosure of proprietary and confidential information, right? We're used to that. The second one is, you know, can limit the employee's use of employer's name, logo, trademarks, yada, yada. Not too surprising there either. The third one is that employers can prohibit the posting of photos of coworkers without their written consent. And this fourth one is I think one of the bigger developments from this case. Employers can prohibit the use of social media to disparage the employer or others. Employers can also prohibit the prohibition of inappropriate communications generally on social media is permissible now, as well as the prohibition of sharing of employee compensation information over social media. So again, this case gives employers a lot more opportunity. We get a lot of calls from employers who are dealing with this, with employees who are, you know, leaving disparaging remarks with the company, and this is a pretty helpful development. Lastly, our last topic we're going to go over here, and it will only apply to religious employers, is what we call the ministerial exception. Just as a quick refresher, this applies again to religious organizations. It's based on the First Amendment of the Constitution and prevents courts from applying, you know, certain employment laws that would interfere with the religious organization's decisions regarding its ministers. And it broadly defines ministers as those who are generally expected to carry out some sort of religious function within the institution, not just ministers in the traditional sense. And once an employee is deemed to be a minister, this exception is generally precluded discrimination and retaliation claims. And it hasn't had too much traction in the Supreme Court. In fact, there's only two main cases where the Supreme Court has even looked at this. Most of it's in the circuit courts. But in July 2020, you'll recall we discussed the Our Lady of Guadalupe School versus Morrissey Baru case. And that the U.S. Supreme Court basically held that, you know, discrimination, retaliation claims cannot be brought by certain ministers. In this case, it was teachers at a religious school. Even though they were teaching secular subjects, the fact they had some religious function, they were considered ministers. But that case left open the issue of whether harassment claims could be precluded. And that's what brings up this new case, Christopher Orr v. Christian Brothers High School, which was just published in November of last year in the Ninth Circuit. And this is actually a case that our firm was handling and still is handling. This involved a Catholic school principal in Sacramento who claimed he was terminated for racially discriminatory reasons and subjected to retaliation and hostile work environment. Now, we won on summary judgment in this case in the district court, and based on the ministerial exception, the court agreed he was a minister. The principal appealed to the Ninth Circuit, and then the Ninth Circuit held that a principal is a Catholic, in a Catholic school is considered a minister under the exception. So that was pretty obvious to them. But next they held, and this was the bigger development, that the ministerial exception can preclude harassment claims. And because to the extent they involve the evaluation, governance, or administration of a minister. But it was very fact intensive. They looked really closely at the specific facts of our circumstance. And they envisioned, you could tell by the argument as well as the opinion, that there will be instances where they likely would find that harassment claim wouldn't be prevented. So there's an old case called Ballard where, for instance, pornography was shared with a Jesuit employee. And there was no real governance or evaluation or administrative function that could even remotely be associated with that. So another thing that the Ninth Circuit held in this case that was helpful was that a handbook's vague reference to anti-harassment or discrimination, if it's a religious organization, that won't waive, that doesn't necessarily waive the FEHA religious exemption. So that was another positive development there. So with that, just want to let you all know we're working on our 2022 Labor and Employment Webinar Training Calendar, and we do hope to have that out to you and available in the next couple of weeks so you can plan ahead to attend those. If you have any additional questions, we're going to see we're out of time here, unfortunately, but feel free to reach out to any of us. Our contact information will be in the follow-up email that will be sent along with today's PowerPoint deck and a recording of the webinar, so you could review this and passively listen to it when you mow the lawn this weekend. But again, thanks for joining us today. Also wanted to mention this year, we're going to be starting our video blog, which is going to take the world by storm. So be ready for that. And with that, we're at 11:37. We might have lost some of you to lunch. But Ramona, I don't know, do we have time to answer any questions here?
Ryan, it looks like there's just one in the Q&A, and I think it's pretty straightforward. So why don't we just do it for those who are still on the line? It says, for small employers, is a self-certification of vaccine status still acceptable, or do we need to see a copy of the employee's vaccine card? The Cal-OSHA ETS does not require that the vaccine card be viewed. Self-attestations are still an acceptable form, as far as I recall. If somebody on the line, Megan or somebody, thinks I'm incorrect, please correct me. But it is the federal ETS for large employers where you would need to see the vaccine card or some other proof of vaccination. So I hope that helps. And thanks again, everybody, for attending today.
Thank you.